Today's portion of the Raymond Davis case is Day 5, a motion to continue brought by the state. It's dated July 22nd, 2019. And the reason that the state was requesting a continuation is because after a previous calendar call, two motions were brought forward by the defense. One was a docket motion, and one was a list of alibi witnesses. Now, the alibi witness list is deficient because it doesn't include what the alibi is, so there's nothing for the state to investigate, which Ms. Collins elaborates on. And the docket motion is to argue for a speedy trial. And docket was a case from 1992 where the prosecution let there be a massive lapse in time between when Doggett was arrested versus when he was indicted. And that was a landmark case because it was 8.5 years between when he was arrested and when he was indicted. So those are what's going to be discussed in today's hearing. Enjoy!
Court is now in session.
We're just going to wait for my clerk really quick. All right, we're on the record. All right. So we are on the record in C-340075, stating Nevada versus Raymond Davis. Mr. Davis is present out of custody with Mr. Maynard and Mr. Mueller. Ms. Collins on behalf of the state. This is the time and date set for trial. I did receive, filed in open court, and a courtesy copy was sent over this morning, state's notice of motion and motion to continue trial. And the basis of that is it states that on, I think it was on Friday at like 4:48, a notice of alibi was filed.
And I think it was 4:43, Judge, if that was a typo there, I apologize.
No, and it might not be. That's just me going off my memory. But either way, it was sometime after 4 o'clock on Friday that the alibi notice was given to the state. And I think that there are, how many alibi witnesses? Is it 10?
There was 10, Your Honor, one out of state, and no substance of what the alibi is.
Okay. All right. So, I mean, obviously, I think we can all agree that that's in violation of NRS 174.233 subsection 1, which talks about the protocol that defense has to file in regards to alibi defense witnesses. So where are we at, Mr. Mueller, Mr.
Well, yeah, and I knew we were going to be addressing that. I personally would suggest that for the possible judicial economy here that we address the docket issue first, because there's at least a possibility that could solve the whole problem.
Sure. The thing about the docket motion is that in doing so, most of the courts have hearings in regards to the factors that need to be decided, especially like I've seen in several of them, detectives come and discuss, this is why I did this, this is why I didn't do this then. When the victim and the defendant are parties that know one another, then, for instance, let's say the mother of the victim came in and said, he knew about this, we talked, I told him about it, I don't have any of those facts before me. So in order to do either an oral ruling or a written ruling, I would have to have that hearing to discuss those factors, the Barker factors and the Doggett factors. I mean, I think Barker versus Wingo lists the factors, and then Doggett goes into a little bit more in depth in regards to the 4 factors. But either way, in order to make an informed decision, I would have to have a hearing.
Okay. I thought that's what we moved up to today, to in front of the trial for the purposes of addressing it.
So I wanted to hear your guys' arguments, but when I went in and I started reading both Barker and Doggett in depth, as well as the, I think it's the Anunza case that Judge Ellsworth decided upon, especially Anunza, it talked about the hearing. And so if you prefer just to, argue it out, I think it's always best to have a hearing so I can be given all of the, information. So I wouldn't imagine that either side has any of the witnesses here today in regards to that.
The state wasn't prepared to offer any evidence today for an evidentiary hearing. In light of the argument I heard in front of the Nevada Supreme Court on Friday, which is in Nunzo, that was actually argued on Friday, and looking at a couple of the other cases that have been heard, I agree with the court that we do need an evidentiary hearing, but I did not bring forward any witnesses for us to have.
Okay. And so that's why we're kind of in a little bit of a conundrum here, right? Because the defendant has invoked his right to a trial within 60 days, which I completely understand and appreciate. There's the dogged issue that's still outstanding, and then there's the issue of the alibi witnesses. So I'm in a position where I believe that if you wish to pursue the dogged issues, that we need an evidentiary hearing where potentially your client would need to testify, and Ms. Collins would need to have either the detective, law enforcement there, possibly the alleged victim, her family members, things like that, to testify, because otherwise I don't really know how I can go into those 4 factors without understanding the facts that surround it. So, which brings me back to the alibi witnesses. I mean, at the end of the day, if these witnesses are important to your defense and you feel like you need them, then you're going to have a conversation with your client about waiving his right to a trial within 60 days because this was not filed in conformance with the rules. And so I don't know if you've had the opportunity to have that conversation with Mr. Davis, but if you believe as his counsel that those alibi witnesses are needed, then we're going to have to pass this to the September staff, because this is my last staff this week. I start civil next Monday, my civil stacks. And so September is the soonest that I have for individuals. I'm happy to keep him in invoked status. He would just have to waive whatever it is, the 30 days to get us to the September staff. That would allow a docket hearing, and that would also allow you to properly notice the alibi witnesses. So it's either that, or you go forward, waiving the dogged issue and the alibi witnesses. It's probably something that you guys are going to have to discuss with Mr. Davis outside for a moment.
And we have discussed it, but we will take a step outside
Okay.
and discuss it.
Sick. Disgusting.
When is the next time we have a Thursday opening for hearing?
First available would be September 5th, and after that would be 1926. They're open out.
Okay.
Do you do evidentiary hearings on Thursdays or Fridays?
We do them on Thursdays, but if I get into a bind where I feel like one needs to happen, then I just try to plug it wherever I can.
supposed to have any contact with minors, so it probably shouldn't be in the shop on the strip, right?
Well, the shop on the strip is being one shop, so it should be, they're not legally allowed to be there anymore.
I'm gonna submit that to her, if she thinks it's tantamount to him being in custody, then I'll let her make the decision, but based on his history, these other arrests, I can't agree to it, that makes sense.
Sure. All right. Should I pass it?
All right, we're still on the record. We're back on C340075, State of Nevada versus Raymond Davis. Defense has had an opportunity to speak with the defendant, Mr. Davis, in regards to what we were talking about.
Yes, and here's the issue, Your Honor. We wouldn't necessarily object to moving to the next, again, we would want to stay invoked. We wouldn't necessarily object to moving to the court's next stack, which was September, correct?
Yep.
However, Mr. Davis is on an ankle monitor at this time. He's unable to, go effectively. He's got a shop on the strip. He's got a gambling shop on the strip. He's unable to take care of his store, and he's unable to make any money while he's got the ankle monitor on. He looked into, getting a temporary job while he's pursuing this case, so he's unable to pay for his defense. So we wouldn't oppose the continuance, again, remaining invoked, but we would ask at this time that he be released from the electronic monitor.
So I don't have anything in front of me. I literally know, and that's why these things have to be done in writing, because I know nothing about his criminal history. So I'm definitely not going to consider anything not being in writing and not hearing about the facts that I normally have to consider. Sorry, can you help me understand about the shop on the strip and the monitoring and how it's affecting it? Is one of the conditions of that he not be on the strip? Like, help me understand.
Well, as I understand it, just a quick second.
Mr. Davis runs a retail store, Judge. He goes down and buys wholesale in California, hauls it up here and sells it retail. And it's fairly profitable. That's how he supported himself for 10 years. With his house arrest bracelet, he can't leave the state. That's the practical problem. So he can't go down and buy wholesale goods to come bring back up here and sell. So it's been a distinct disadvantage to him. In fact, it's been a destitution of him to not be able to leave the state.
What I was explaining to Mr. Maynard before you got here, though, is that's why these motions have to be done in writing, because I have no understanding of his background, any criminal history, where he's from, local ties to the community. So there's no way in a case with a life tale that I'm just willy-nilly considering these types of things. You would know as well as I do that on a lot of these charges, generally people are in custody. So I don't have any problem with him being out of custody. I just can't make an informed and an educated decision without any information.
Well, Your Honor, I can tell you that he's been a resident of the same address in Nevada for the last 10 years. He's been a resident of Nevada for, I don't even know how long. 10 years. Over 10 years at this point, because he had more than one arrest since 2000. We do have his pretrial risk assessment sheet.
Is there any criminal history?
It looks like they have on here that there were a few things in Washington back in 91 and 93. But, that was so long ago at this point. At the time, no failures to appear, still none. Looks like there may be a misdemeanor conviction on here. Yeah, his history is minimal at
When we were here at the calendar call, I remember Ms. Collins stating that there was going to be some if you had an OBA witness, you'd be filing a motion for other bad acts. What was that in regards
That's
to?
correct, Your Honor. That is a 2004 case where the defendant was convicted of annoying a minor. It was charged at the inception with kidnapping of a minor and annoying a minor. He was picked up at the Plaza Hotel with a 14-year-old and a 15-year-old girl. The one girl reported knowing him since she was 13 years old, and she was a runaway from California, therefore the kidnapping charge. Neither one of those girls disclosed any sexual conduct. However, in, looks like 2005 in Huntington Park, California, he was arrested for sexual conduct with a minor, and in, I believe, 2000 in the Haywood Police Department in California, he was also had contact with law enforcement regarding sexual conduct with a minor. So this is his fourth, if you will, brush with the law regarding minor kids, minor females specifically. Even though the first two from California did not culminate in a conviction.
I understand. I mean, there's no way I'm changing that, especially without writing. If you want to put something in writing that assures me of some of the concerns I definitely have now regarding those representations, I'm always happy to consider it, but as we stand here right now with nothing before me, there's no way I'm changing it.
Well, Your Honor, we would be welcome to intensive supervision where he checks in with the jail once a week. He would still be able to have a certain degree of mobility with that. It's just at the moment, especially with the continuation, one of the reasons why he has remained invoked is because this process is crippling him financially.
Well, I understand that, but the thing is,
And in addition,
hold on, I'm not done. The calendar call was last week. You didn't have a docket motion done until after calendar call, and you don't have alibi witnesses until the Friday afterward. So, I mean, some of this onus isn't on anybody else. So when we're filing motions past calendar call and we're filing alibi motions not within conformance of the statute, that falls on the defense. So if you would like me to readdress the custody, modifications of him being on house arrest, I am happy to do so. It must be done in writing. Like I said, if you have spoken with the defendant and he wishes to waive those other issues that you guys have brought up, let go of the alibi witnesses, let go of the docket issue, I'm happy to start trial, but those decisions all have to be made.
if we could get just another moment to speak with our client, we'll have a final call on this.
Sounds good? Yeah, in October first, but I don't think you guys could try this in 4 days.
Every single stack is one.
Huh?
And then like boil them. Oh, I didn't know. Something new.
I don't know if there's anything we can do about it, really.
Is that for a ship off, like a short one, so it's.
Yeah.
Is there one stack that's lighter than another? No.
Then like, let's see, on the 3rd, there's 12, on the 9th, there's 11, on the 16th, there's 12, the lightest, 23rd, there's 10, that's the lightest. The 30th, there's 11, so yeah, 10's the lightest.
If this case stays how it is, it could go to overflow.
Oh, it's within a week?
Well, as it is now,
Okay.
might not stay there though.
All right, Your Honor, I think this has been resolved for the day, at the very least.
Okay.
We will, again, remain in vote, we will not object to the continuance. Can we put the docket motion back on for hearing on, I believe it was on the 29th originally, before we had it moved up? Can we just scoot it back to its original date?
Courts and buildings, please.
Hey, wait, I'm sorry, 1 second. So that's next Monday.
I just have to be in Henderson.
So
for-
here's the thing, I could potentially do it on that Monday. The only problem is if tomorrow one of my civil trials announces ready, they could potentially be starting on that day. So what we could do is we can set it with the understanding though is if one of my civil trials starts, I'm not gonna be able to do it on that Monday.
Could we, I mean, I don't know how civil trials work, do they do the half days as well? Might we be able to slide in the morning?
No, because I'm criminal on Monday mornings. So
Okay.
my criminal calendar lasts the morning and then the afternoon I start trial.
Okay, if the civil trial starts on Monday, do you know how long it would last? Is it expected?
I think we have, I don't know how many, I think we have like 10 trials that need to find a place. So that's why, I won't know anything until tomorrow, but that's why I'm saying, why don't we schedule it for Monday at 1 o'clock for evidentiary hearing? Ms. Collins, will you be back from Henderson?
My experience in Henderson is that it's really slow. And if I have to put that prelim on, which as of right now it's going, and you know, that could change at any moment, but it doesn't start till 9:30. And it is multiple count, small child, so, I mean, I can tell you I'll be here.
What about what about Tuesday afternoon for both of you? The 30th.
I could do,
Better.
yeah, I
Okay.
can do the 30th.
So let's do this, let's set it for Tuesday the 30th at 1 o'clock. But I just want everybody to keep in mind, if that civil trial does start on that day, I'm gonna have to move it. So we can just hope that the civil trial doesn't go, and so that,
I would ask this, if it's gonna go, is it gonna go on Monday, is it gonna start on Monday, is there any possibility that it would start on Tuesday?
shouldn't, see what happens is civil runs way different than criminal. On criminal, like everybody's given a specific date. In civil, everybody's given the start date of the 22nd, and then however many go, you plug them into the months to see who will fit where. It's way different.
Okay.
And so I don't know any of those answers, but I will know them tomorrow. My calendar starts tomorrow at 9:30, and so I'll know. So we'll just send you guys an email tomorrow afternoon when we get out of court, and hopefully there won't be an issue.
Okay, just a moment.
Okay.
All right, all ready to go.
Okay, so let's do Tuesday the 30th at 1 o'clock, please.
July 30th, 1 PM, evidentiary hearing, docket motion.
And then, so for the record, the state's notice of motion and motion to continue is granted based on the, late notice of the alibi witnesses pursuant to NRS 174.233 subsection 1. The defendant is still going to be in invoked status. I'll just move him to my next date, which is September. Mr. Davis, do you understand that I am still keeping you in invoked status, meaning you still have a right to a trial within 60 days, you're just going to be waiving that 30 or so days so we can get you on the next criminal stack, which starts in September. Do you understand that?
Yes, I do.
Okay, so September 3rd, 9th, 16th, 23rd, and 30th are the dates.
What was that again?
So it's the whole month of September.
Okay.
And I was just stating the first
First day.
days of each of the weeks.
Okay.
So Ms. Collins, how many trials do you have set in September?
Well, my biggest issue is the show, which is set Monday, I'm sorry. He set calendar call a month ahead of time. Great. Calendar called on my trial, on my calendar, but the trial date is not. Of course, it's just one of them.
If you have the case number, I'll look it up.
It
One
is.
second, let me log in. Okay, go ahead.
C307515. I'm just wondering if that was.
For dad or mom,
For dad, mom's in prison.
September 14th.
Okay, so that's a 2-week trial. It can't be September 14th because it's Saturday.
Oh, September 14th, 2020.
Wow.
Yeah.
So that is totally on my calendar in error. All right, well, that's good news for in here.
Okay.
September 9th would be great, because I know that trial I already have on the 9th is getting vacated by motion this week.
I'm trying to get a hold of our trial sheet really quickly. I think, what's the first Monday of September?
Labor Day.
It's Labor Day. So you'd actually start on Tuesday the 3rd.
How many days you think this will take?
It'll probably take the full 5.
Is that counting if they call any of the 10 alibi witnesses?
No. No, if you call all those people, it's probably gonna take 7 days to try this case.
All right, so it's just 5 for yours?
That's what I anticipate, yes. So with 10 witnesses, with one full day, 1 half day, think you can get them done?
So,
Yeah, September 9th will work.
okay, so let's do September 9th trial date.
Yes, sir. Calendar call September 4th, 9 AM, jury trial September 9th, 10 AM.
And then, so any witnesses that either side believes they need for the dogged hearing, just make sure you have here on Tuesday with either side, okay? And then, I did have a exhibit, is this court's exhibit or state's?
Court's exhibit,
And, tell me what it is.
that is the filing time for the alibi notice.
Oh, okay, all right, so that'll be the court's exhibit.
If I may just be heard very briefly, Your Honor?
Yeah,
So this continuance will cure the timing of the alibi notice. It still is facially deficient as to substance.
right.
It doesn't have any of the information in it. So that needs to be cured 10 days prior to trial next time, if they're gonna do that. I mean, because as it is right now, it doesn't really tell me what the alibi is or what it consists of. For me to I don't even know what to investigate based on that, so.
Okay,
Okay, I will make a note of that.
got it. All right, so the current trial's okay. Can someone let jury services know? They have a bunch of people waiting for them.
Your Honor.
Okay, all right, we'll see you guys next week.
See you next week.